Hello viewers, welcome to our channel Rising Legal. Today in this constitutional law class, I am going to discuss an important topic that why right to property have been abolished from fundamental rights to basic right. Viewers, in the original constitution, the right to property was a fundamental right. As per Article 31, Clause 1 of the Constitution, no one could be deprived of his property save by the authority of law. This meant that a person's property could be acquired by the state only by the consent of the nation as embodied in the laws passed by the legislature as per the Constitution. The private property could neither be taken away by an executive order nor could be seized by the police or the government without the authority of the law of the land. Actually, our today's topic is that why right to property abolished from fundamental rights to the basic rights. And this particular portion of the discussion it provides regarding protections to the citizen against the executive orders but not against the legislative act. In addition, the Constitution provided to every citizen the right to acquire any property by lawful means such as inheritance, purchase out of personal earning, or lawful transfer. Similarly, every citizen could also dispose of his property, but these rights were subject to certain reasonable restriction. Viewers, in addition to the above two provisions, the Constitution also provided that if the state wanted to acquire or requisition the private property of an individual, it could do so only on two conditions. Firstly, such acquisition or requisitioning should be for a public purpose, and secondly, whenever such an act was done by the government, it must be done for an amount to the owner, and such an amount was to be determined in accordance with the concerned law. The nature of rights to property has undergone several changes since the commissioning of the Constitution. First, 4th and 25th and 42nd Amendment to the Constitution brought about several material changes to the right to property. The courts have also given some interpretation in the meanwhile. The Supreme Court of India has held that the compensation for acquiring or requisitioning the private property has to be full compensation. It means that without giving full monetary equivalent of the property of an individual, it could not be acquired or used by the state. 25th Amendment to the Constitution replaced the word compensation by the word amount. The government also introduced certain exceptions to Article 31 Clause 2 and Article 31A was introduced to enable the government to introduce law relating to the land reforms under which the tenants were given ownership right over the lands being cultivated by them, and the government could take over the surplus or excess land for allotment to the landless poor. Viewers, it also enabled the government to take over the private property for a short duration in the public interest. Further, Article 31B arms the state with the power to cover certain enactment under the 9th schedule of the Constitution. New article, that is Article 31C inserted by the 25th Amendment, provides that any law seeking to implement the directives under Article 39 Clause B and Article 39 Clause C shall not be void for inconsistency with Article 14, 19 or 31 of the Constitution. 42nd Amendment to the Constitution, viewers, it also enlarged the scope of Article 31C, which all such laws were given protection that aimed at implementing any of the directives in Part 4 of the Constitution. 44th Constitutional Amendment, however, eliminated the right to property from the list of fundamental rights. It took Article 31 Clause 1 out of Part 3 of the Constitution and substituted it by another article, that is Article 300A. As a result, the right to property has now been reduced to the status of a legal right. For violation of this right, now no one can have a speedy constitutional remedy under Article 32 of the Supreme Court or High Court. Hence, as per the present position is concerned, the citizens of India do not have any granted right to compensation if their property is acquired or requestioned. But there are two exceptions. Firstly, if the property acquired belongs to minority educational institution, the state must offer full market value or compensation, enabling the minority community to set up another such educational institution. Second thing is that if the land being cultivated personally by an individual is to be acquired, the state must pay full market value as compensation. Now viewers, abolition of Article 19 Clause 1 and Article 31 Clause 2 of the Constitution changed the very character of the right to property, and a private owner today may not be paid full monetary value of his property acquired or requestioned by the state. The critics feel that there is some scope for providing full monetary compensations to the poorer section among such property owners. There appears to be no move to amend the constitution on these lines, and many feel that relief of this section may finally come from the Supreme Court in some of the pronouncement on the issue. So viewers, that is our today's discussion. Why right to property is no more fundamental rights, why it is now as a basic right. Hopefully you all understand our today's discussion. Lastly, I am thankful to all our viewers who are actually watching our channel, who are actually supporting our channel. Thank you very much. Thank you to all of you.